Mr. Smith.
May it please the court, my name is Mark Smith, counsel. I'm the state appellate defender. I'm here representing Andrew Lopez. This case was framed as an ineffective assistance of counsel claim based on a breach of a plea agreement. But unlike most ineffective assistance of counsel claims where you have to talk about did the defense lawyer fail to do something and did prejudice result, really the focus of this case is on one thing, and that is, did the prosecutor breach the plea agreement? Because if the prosecutor breached the plea agreement, it is clear from the record that the defense lawyer did nothing to correct that, and that because of the sort of dual interests that are involved with general plea bargains and the obligation to comply with those plea bargains, not only has the defendant given up fundamental rights in return for something that he didn't receive, but the whole system would sort of collapse if we can't depend on prosecutors making promises and fulfilling them to the letter.
Can I ask a factual question? Because as I read the code, this guardian ad litem came and testified at the hearing, but I'm unsure in reading the code as to who notified that person to come and who said that person could testify. I went to the docket and I didn't find anything. We don't have access to a lot of stuff unless it's sent up here. But is there any way in anything in the record that you know of how that person was called upon to testify? And I'm concerned whether the county attorney asked the person to testify, whether the defendant asked the person to testify, or the clerk just sent out a notice just to send out a notice. So that's what I'm trying to figure out, who required or requested that person to come.
I don't think there's anything specific in the record. I do think that the guardian ad litem, when she was giving testimony or reading her statement, and it's unclear to me, I don't believe it was, it may have been written, but I don't think the written statement is actually an exhibit, for instance. My recollection is that she said that she had attended the plea proceeding, which had occurred sometime before. It's unclear why she attended the plea proceeding, but that she had. And I assume, as an attorney who practices in that county, she had access to whatever happened to be going on in various criminal cases. So it's unclear to me why she was there. I do know that the record does reflect that at the sentencing, the prosecutor called her as a witness.
Well, I read the transcript and no one called her as a witness. What happened was the court started the proceeding, and this is why I'm confused, and maybe I'm not confused, but as I read it, the court started the proceeding and said, we'll proceed with the victim impact statements, and those two people just gave their statements. No one called them as a witness. They just got up and did it, and that's what I'm trying to figure out is how they got there. And the other question is, why didn't your client's attorney object to it as being an improper person?
I have no clue as to why the attorney didn't object to the person giving whatever this statement was, and to characterize it as a victim impact statement is sort of stretching the definition of what a victim impact statement is, because the first words out of this person's mouth was, this person does not deserve a deferred. It has nothing at all to do with the effect that this crime may have had on the victim.
That's what victims normally argue. They're not there to talk about something abstract. They're there to advocate for a particular sentencing outcome, right?
Well, take a look at the father's statement on behalf of the child. He talked at great length about the effect of the defendant's actions on the victim.
Let me just give you my take. I will just say personally, my reaction on reading this appeal, I am less troubled by the GAL being allowed to appear as a representative or attorney for a victim. I'm really interested in the use of the photographs and the questioning of the character witnesses that the defendant presented. I'm very interested in what the prosecutor was doing there and whether that breached the plea agreement.
Well, that's what I believe as well. And if you'll notice, that's what I talked about the most in my brief, and that is that, in fact, all the prosecutor did as far as recommending this deferred judgment was say, we've got an agreement to recommend a deferred judgment, and did nothing else. All they did was introduce these photographs, which had no business at all in the sentencing proceeding. They may have been helpful at the plea if the issue was, can they show that this child had a bodily injury, but they have no reason to be at the sentencing proceeding. Now, the Court of Appeals sort of discusses that, saying, well, they were in the court file, the court could have looked at them anyway, even if the prosecutor didn't do that. But that's not true. They were introduced by the prosecutor at the beginning of the sentencing proceeding. They were not part of the court file. They're not attached to the minutes. They're not attached to any police reports. They're not attached to anything. They were not part of the record until the prosecutor put them in. And the prosecutor could have had no purpose in putting those in there and then using them to undercut what the witnesses for the defendant were saying as to why this guy should get a deferred.
You know, is one theory for a legitimate purpose for this cross-examination is that the character witnesses testifying in support of a deferred were saying, hey, you know, I'll make sure he complies, we'll keep an eye on him. But did they really know him? Did they, know what he did to the child? Is this a way to test the veracity of their assertion that he's okay out on the street, we'll keep an eye on him?
Well, but the prosecutor's obligation was to advocate for that result, to get this person out on the street. He said that that's what he would do. And all he did was give the court all kinds of reasons why that shouldn't happen, as opposed to presenting reasons why it should.
Is that really, error that affected what the judge did in this case? Because if you read the judge's reasons, they seem to be sound. And then if you read the PSI, they didn't recommend a deferred. They said he was in the high to moderate range to reoffend and recommended a suspended sentence, but said he had to live in a residential facility. So, I mean, even if this prosecutor may have stepped over the line, do you think it really affected the judge's decision based upon the reasons the judge gave in the PSI?
We can't know that because the prosecutor didn't do what he said he would do. We don't know what effect the prosecutor actually recommending a deferred judgment would have had on this particular judge. When we find a
breach of the plea agreement, do we then require the defendant to show that the breach resulted in a harsher sentence or a harsher result, or do we just send it back?
I think you have to send it back. And the reason for that is, as I say, there is sort of this dual problem with breaching the plea agreement. And that is, it not only affects the defendant's rights, he didn't get what he bargained for, but it also says that our system, we can't depend on half of the system to work correctly. That is the prosecutor half.
So in that sense, your position is it's like a structural error
in the sense that prejudice is presumed. That's correct. It is, we expect prosecutors, and the courts have said over and over, we expect prosecutors to follow their agreements. And we expect them to do it not only by just making the recommendation, but by advocating for it. For instance, in this case, if the prosecutor said, we're going to advocate for prison time, you can bet that the prosecutor would have pulled out the PSI, they would have pulled out everything that this person had ever done in the past and argued that this guy needed to go to prison. But what did the prosecutor do in order to suggest that the judge should give him a deferred? Nothing. And did only undercut what he promised that he would do.
Do you allow him that?
How enthusiastically does the prosecutor need to support the recommendation?
Well, the cases say that, and I'm talking Beers and Horness and those cases, indicate that they have to at least commend to the court that the prosecutor supports it. And in this case, the prosecutor did everything they well, not everything possible, but they certainly did everything that was convenient for them to do to undercut what they had suggested that they would do.
Well, what do you make about... also to withdraw the guilty plea?
Pardon me?
Do you allow him to withdraw the guilty plea?
You know, the normal sort of remedy is, I think you give the defendant the, you know, either withdraw your guilty plea or go back and make the prosecutor comply with the plea agreement. And as I indicated in my brief, I don't think it's possible for this individual prosecutor to back off of what she did at the proceeding. So I would suggest if it goes back, someone else needs to comply with the plea agreement or allow the defendant to withdraw his plea. But the issue is, did the prosecutor breach the plea agreement? And the answer is, they clearly did in this case.
Let me see if I understand the remedy. I mean, normally if we find a plea agreement is breached and we remand for resentencing, we say by a different judge. Are you suggesting that we also say by that the state be represented by a different prosecutor?
I believe I said that explicitly in my request for relief. That is correct, Your Honor.
Mr. Smith, let me ask you just a clarification. You are asking of remedies, either that we remand to allow him to withdraw his guilty plea or remand for new sentencing?
The general sort of remedy is that sort of alternative thing. I'm suggesting that it needs to go back and it needs to have a prosecutor that is willing to abide by the agreement that they made.
Okay. And this is raised for us in the context of an ineffective assistance of counsel. So
right.
Even if everyone in the room would agree that the plea bargain was not complied with by the introduction of this evidence that was contrary to the agreement, before we would then have to ask the fundamental question, was counsel ineffective for failing to object to it? And I think maybe if everyone agreed that that was the case, then we'd have to move on to the next question of whether it was prejudicial.
No, I don't. Well, the answer is yes, you have to answer that question, but the answer is fairly automatic once you determine that the prosecutor breached the agreement. Because the cases say clearly, if the prosecutor breaches, the defense lawyer has an obligation to object, and they didn't.
We say in Beers, you know, you don't go to the prejudice.
Right.
Once you show the failure to perform the essential duty, it's over. I think you go through the analysis because it's ineffective, but the result is automatic. You presume that the prejudice occurred because of the failure to object. But the point is, you don't require the classic demonstration that the outcome would have been different.
No, because and the Court of Appeals sort of, I think, talked a little bit about the prejudice thing, and I think their response is like, no harm, no foul. This guy wasn't going to get a deferred no matter what happened. But we don't know that. The prosecutor said they would recommend a deferred. They didn't recommend a deferred. That's wrong.
What do you make of the last part of the hearing where the prosecutor accurately reported what the plea agreement was?
That's the only thing he said to commend the plea. That was the absolute only thing. But you
I think the argument is, I think the state's argument, not to put words in her mouth because she's going to be before us shortly, but the notion is, well, we agreed to a certain plea, and that included recommending a certain disposition. In fact, very accurately, the last paragraph or two of the transcript is 100% accurate. We reported the terms of the plea agreement. Don't worry about the rest of it.
But you have to worry about the rest of it. It's not just that they had an agreement. The agreement was that they would recommend a deferred. And all they said was, we're recommending a deferred. They didn't give the court any reason to go along with the recommendation. And that's what's wrong. Thank you.
Ms. Chambers?
May it please the court. An agreement to make a particular sentencing recommendation does not require the prosecutor to hide the evidence from the district court, to avoid the difficult sentencing issues presented by a case, or to silence the victims of a crime. Here, the prosecutor agreed to recommend a deferred judgment. Both at the beginning of the hearing and at the close of the hearing, the prosecutor did just that.
How genuine is that when you do that and then you do everything that a normal person would do to try to get a more serious punishment than you're commending to the court? Like, for example, letting that guardian ad litem testify, and if you read her testimony, it was pretty powerful because she never did it before. This is the first time in her 30 years, but she had to come here to make sure this guy goes to jail. I mean, to allow something like that, when I think the law is pretty clear, she wasn't a victim.
There are several issues there, but let me start with the last one. It is not at all clear that the state called the guardian ad litem.
Well, it isn't, but the court says your next witness, page 8 in the transcript.
Sure. That's the court's characterization.
And characterizes it as evidence for the state. And that wasn't objected to. I guess that's all we have.
That's all you've got.
In terms of how she got there. I mean, I take it there's nothing else in the record as to how all this occurred.
Sentencing hearings are different than trials. At the trial itself, the prosecutor has complete control over who testifies for the state. At the sentencing hearing, the prosecutor cannot actually prevent a victim from giving an impact statement in writing if he or she chooses, and in person if he or she chooses. The prosecutor cannot control that. So regardless of how the district court may have characterized the victim as a witness, is not very really relevant here.
Can there be more than one victim impact statement for this child victim who's obviously too young to testify?
The defendant argues no. That flies in the face of the language of the statutes and the practice in our district courts. It is routinely the case that more than one victim testifies in a case. For example, in this case, the father testified, but he is not the custodial parent. So he is probably not in the best position to say how this crime affected the day-to-day life of the child.
And is the father a victim himself?
I believe he is, under the definition of the statute, yes.
Is a guardian ad litem a proper person to make a victim impact statement?
The statute doesn't say who that representative of the child can be. A guardian ad litem certainly seems like an appropriate person to fill that role. I think it's pretty clear from the record that the guardian ad litem was appointed to represent the child in the juvenile proceeding. So that would be a person who would already be well acquainted with the facts and with the child and would be aware of what was going on. It seems to me that would be an appropriate person to speak on behalf of the child at the sentencing hearing, and nothing in the statute would prevent that person from.
But doesn't she not, we defined what a victim was in State versus Tesh, and we were pretty clear. I don't know if how does she meet that definition in Tesh? Because
the statute says the victim. I think in Tesh the issue was whether that was a victim. The guardian ad litem testifies on behalf of the victim who's under 18. Under the statute, someone is permitted to speak for the victim, for the child victim. The father speaks as a victim in his own right because he meets the definition of a victim under the statute. The guardian ad litem meets the definition of the statute for someone to speak on behalf of the child. And potentially they both could be speaking on behalf of the child as well.
Let's talk about the photos. They were used to cross-examine at least 3 witnesses, and we've all read the transcript. The 3 witnesses included the friend, this Sheldon Whitmer, who was going to kind of supervise, if you will. That's where he was gonna live. And also stepmom. And it seems to me, as I look at the examination, it's pretty clear that the photos were used to undercut the credibility of these witnesses. So how does that support the plea agreement?
I'm not sure that I agree that they were used to undercut.
Oh, my. Let me give you some of the cross-exam then. On Sheldon Whitmer, he says, well, he's a close friend. He'll stay with him, make sure he's going to go to appointments and so forth. Shows a photo. It's a pretty horrible thing to do to a 2-year-old girl. So, yes. So it seems fair to say that there's a side to him that you haven't seen before. So in other words, implying he can't supervise. Amber Lopez, stepmom, the photos are showed. Is that what you would expect to have happened that night? Is that better or is it worse? She says, well, I could never imagine. And the prosecutor cuts her off. Thank you. Danny Lopez. It's fair to say those pictures are kind of shocking, right? Frankly, it seems to me it was a fairly effective examination, undercutting the credibility of these witnesses.
Here's the thing. Under some circumstances, I would probably agree with you. But in this case, okay, we all know that this defendant had a very slim to zero chance of getting a deferred judgment. And then he came into court, and here is his plan.
Really, when they had to deal with a prosecutor?
Prosecutors make recommendations all the time that they know the court will never follow.
Well, I understand, but to characterize it as slim,
Slim, I think, is being generous. Anyway, so then he comes into court, and his plan for how he's going to succeed on this deferred judgment is he's going to live with 2 other teenager or young adults who have a child about the same age as the child he's convicted of abusing. And his father and stepmother are going to provide support. There was no way he was getting a deferred judgment on that record. So I actually think the prosecutor helped him.
But isn't that the problem? Isn't that sort of a no prejudice argument, which we haven't bought in the past?
You haven't,
say now, we really don't. We say once there's a breach, it's over, and we say honoring the plea agreement means more than just kind of going through the rote recitation of what the plea agreement requires, but truly honoring the spirit and the tenor of the agreement. And doesn't it seem that the prosecutor failed to do that here?
I don't think so under these circumstances, because let's say that the prosecutor had not asked any questions of the defendant's witnesses, his chances of getting a deferred judgment were, I think, lower than when he walked into the courtroom.
Well, but that's not...
Because those people didn't know what he did.
The cases, our cases don't seem to say that. I mean, there was some talk about structural error and so forth, and Bierce has been mentioned, and what we have generally said on plea bargains, I think in our case law, and if there's other contrary cases I'd like to know, or maybe you want us to change our rule, which...
Go ahead.
But we've basically said on plea bargains, look, we're going to hold you to the letter and spirit, cite, Bierce in particular, Horness also. If it's breached, we're going to send it back and have a do-over on the plea bargain. Now, if it is true that the line was crossed here, it seems to me our cases make the remedy rather clear. Now, dispute me on the remedies, dispute my view of the case law if you can, or argue for a change in our case law.
I agree that as the case law exists, there is a presumption of prejudice.
Oh, yeah.
The court has not characterized that as structural error. I think they've kind of implied that it was, but the court has not gone so far as to say that. They have, though, and to my knowledge, always found prejudice, and they found that without any sort of prejudice analysis. So
And
why
is that wrong? Are you asking us to change it? I take it you are.
I am asking, for the very reasons that the court is enunciating, kind of, I sense a sense of frustration, as did this Court of Appeals, in that there's clearly no impact on the outcome here. And yet we're going to reverse his conviction and send this back down.
Well, no, I'm not reversing the conviction.
His sentence, we're going to vacate his sentence and send it back down.
And if you're right, I mean, I understand what's in the PSI and all this kind of stuff, and I understand you have a view of what the likelihood is of the recommendation of the prosecutor being accepted. Well, we'll remand it back and we'll see.
I mean, the court can certainly do that. I think you can affirm, but I frankly don't care that much, because here I think there's no breach, and that's the fighting. I mean, he can be resentenced, and it's not a big deal, really. I think he might be careful, defendants might want to be careful about what they ask for. But in this case, the worst he can do is get what he already got. And while I'm not conceding that the court must remand, that's not really where that's not really the fighting issue for the state, because there really is not a breach here.
If we find there is a breach, should we order a different prosecutor, or can we even do that?
No, this court...
This violates separation of powers, doesn't it?
This court vacates sentences, reverses convictions, and sends them back all the time for the same prosecutor to do the proceeding over. All the prosecutor has to do would have to do on resentencing is simply refrain from whatever it is the court tells him, might tell him in this opinion she can't do. There's no reason to believe this prosecutor can't follow the law.
Doesn't the plea bargain system require the prosecutor to make some effort to advocate for the recommended sentence?
There is some language in this court's opinion suggesting that, but they're all made in the context of cases where the prosecutor either affirmatively recommended a sentence other than the agreement, or I think it was in Hornus where the prosecutor said, well, here's what the agreed upon sentence is, but then the PSI has this alternative one, and wink, wink, nudge, nudge, here are all these facts that support the PSI. That didn't happen here. Here the prosecutor gave one recommendation and one recommendation only, and that was the agreed upon recommendation for deferred judgment. Did she ask questions of the witnesses? Yes, but those really demonstrated that the witnesses went into this with their eyes wide open. Even knowing what the defendant did, would you be willing to let him live with you and your family? Yes. Even knowing what your son or stepson did, will you be supportive of him? Yes. That is not a breach of the plea agreement. I think that gives whatever meager support it can to the defendant's case.
Do you think there's a possibility of having a proceeding whereby he would be allowed to withdraw his guilty plea?
The court could, in its discretion, order that the plea be set aside. He hasn't really asked directly. I mean, he kind of made alternative recommendations and argued for that not. I suspect he doesn't really want his plea set aside. He got a good deal here. They reduced it from a forcible felony to a non-forcible and gave him a shot at seeking a deferred. So that may fall into the category of be really careful what you ask for.
Yeah, and I guess that goes back to my real concern in this case is more of a structural error type of analysis, in that to reach a plea agreement on this, and the county attorney or the prosecutor then says, oh, well, yeah, sure, I'll agree to a deferred. I agree with your analysis that the likelihood that this guy, based upon the record and based upon the sentencing judge's comments in there, he's never going to get it. So the whole plea agreement at the outset, to me, is somewhat illusory, and I don't know if that, so that's what my concern is, and that's why I keep asking the question about withdrawing the plea. You're right, you got to be careful what you wish for, and maybe that's not the remedy, but you see where I'm coming from the very outset, that this was not maybe a plea agreement that the prosecutor was ever going to endorse in the first place.
The reduction of charge is not illusory. That's a real big deal. Whether I wasn't, to the extent that the court maybe understood that I was saying the prosecutor wasn't sincere in that recommendation, I didn't mean to imply that. Sometimes both the prosecutor and the defense attorney can agree on what an appropriate outcome might be, even recognizing that what they think should happen flies in the face of what probably will happen. We're going to ask for this. This is what we genuinely think should happen. We genuinely think this guy should be given a chance. But district courts don't have to go along with what they agree. So you can make, in good faith, make a recommendation, even while recognizing your chances of prevailing are not great. And that's what I think this record reflects.
But isn't there something more at stake here, that just the fundamental integrity of our judicial process, that this guy goes into a sentencing hearing, thinks that he has the prosecutor recommending the same thing that he's recommending, and he finds out the prosecutor parades up a couple witnesses and introduces evidence that's contrary to the recommendation that both parties were suggesting. Doesn't that just sort of, how could the defendant ever have any confidence in the justice system that acts like that?
I really, I'm really sort of shocked by the parade up a couple of witnesses. These are the victims who are by statute allowed to give their
Okay,
statement at the
but
hearing.
let's focus
So-
in then on the prosecutor
Okay.
showing these witnesses these photographs.
The prosecutor could have chosen not to show the photographs, sure. And would the defendant probably have been happier? Sure. But the
But does that sound like a prosecutor recommending leniency?
I think,
And what's going through the mind of the defendant?
well, I don't know what was going through the mind of the defendant, and I don't know what was going through the mind of the prosecutor.
What might you speculate, though, that the
Presumably-
defendant would be thinking that when this is all unfolding in the courtroom?
The first thing that happened was that the prosecutor introduced the photographs and the defense counsel did not object. I think it's fair to infer that everyone knew that was going to happen. But even if that's not the case, there is nothing that requires the prosecutor to hide from the sentencing judge the facts of the case. The judge is to make his decision based on the facts of this particular case and the individual circumstances of this particular defendant. It does not advance the cause of justice to attempt to hide from the judge what happened. And all the prosecutor did here was say, Judge, here's my recommendation, here's what happened, here's my recommendation again. The recommendation was proper, the evidence was no more inflammatory than the crime, and how are we to say that a prosecutor breached a plea agreement by doing what the prosecutor is absolutely permitted to do?
Well, do you think the prosecutor ought to include in the agreement that I will make a oral representation of the court to go along with your recommendation, but I'm going to introduce evidence that is contrary to that?
We don't know that that didn't happen. And the fact that the defense attorney did not object gives reason to infer that, in fact, that's what everybody knew was going to happen. I don't think it's fair to infer the opposite, for sure.
Thank you.
Thank you.
Rebuttal?
I actually kind of like what she said because it just makes my case. And that is prosecutors, first of all, shouldn't be making plea agreements that they know are ethereal at best. If they're going to recommend a sentence, the law requires that they do something to convince the court that their recommendation should be followed. This prosecutor did everything she possibly could to ensure that it would not be followed. If you look at the sentencing transcript, my recollection is that, except for the cover page, those photographs were introduced on page 1, the first page of the sentencing transcript. The prosecutor knew long before they made their recommendation that they were going to do whatever they needed to do to undercut it. And that's exactly what happened. Now, it might have been a slightly closer question if they hadn't used the photographs but had just said, you do know, or in cross-examining the witnesses, you do know that this person, was pled guilty and admitted that they abused a child. And knowing that is that you still think you can take it. That would be a closer question. But the prosecutor didn't even intend to go that close. The prosecutor said, I'm going to make this recommendation, and then I'm going to do whatever I can to make sure that the court doesn't go along with it. And that's what happened in this case. And that does hurt not only the defendant and what this defendant might think, but it hurts our whole system. It says we can't depend on what a prosecutor says they're going to do. And this court has said, not only do they have to say that they're making the recommendation, but they have to believe in it, and they have to do something about it.
What about Ms. Chambers' argument that we don't really know the extent of what the agreement was, that we may, I guess she's suggesting that we should just wait and let this be developed in a PCR?
What the prosecutor said the agreement was at the plea hearing was exactly what the prosecutor said it was at the sentencing hearing. First of all, there's nothing in the plea agreement that deals with reducing charges. The charges were reduced. There's no question about that. But there was never a discussion that that's why the plea was going to happen. The plea was going to happen because the prosecutor was going to recommend a deferred, and that's what the defense lawyer attempted to do by calling witnesses. The suggestion that if the prosecutor hadn't sort of cross-examined and destroyed these witnesses, that they were somehow hiding information that the court needed, that's ridiculous. The prosecutor could have just sat there and let the witnesses testify. You're not hiding anything. The prosecutor used those photographs to undercut what
Mr.
they
Smith,
said they would do.
Could I ask you a question about the remedy? In contract law, when someone breaches a contract, if we find there was a breach of the plea agreement, one remedy is specific performance, which would here involve sending the case back for a new sentencing hearing. Another remedy is rescission, which allows the defendant, in effect, to back out of his agreement and to have go back to the situation before there was any deal. What is the remedy that you're asking for here?
We're asking for specific performance if this were a contract, and it is a contract. Thank you.
Why shouldn't we change our law to require the defendant to show prejudice resulting from a breach of a plea agreement?
First of all, because it's almost impossible to show, because we don't know what that judge would have done if the